I heartily welcome all the participants of this webinar. In the today's session, I will be covering this important aspect of Benami transactions and the consequences thereof in three parts. In first part, I will be discussing the basics and the understanding of how Benami transactions are being dealt with and what are Benami transactions, Benamidars, beneficiary holders, and the various aspects related to that. And then how the attachment of the properties, confiscation, etc. goes as per the Benami Act. And then finally, I will be coming up with some posers, questions, which will clarify any doubts in the minds of audience. So in the three ways I will be going. And to begin with, let me start with the historical perspective of this. If we go by the Benami properties and transactions in India, this has been a legal transaction all along. In fact, this has been a popular practice during the British time, and even there are many Privy Council decisions confirming the Benami transactions and giving the rights to the beneficial holders. There have been many instances of legal cases where it has been held that the person who provided the consideration has the right over the property and not the ostensible owner or the mask in whose name the property is standing. So this has been the practice in the beginning, and now it is completely reversed in the sense that now it has become a criminal offense. There are many penalties and other negatives attached to it. I will be discussing those in detail later, but just to give a glimpse of it, now if any property is found to be Benami and it is considered and held as Benami at all stages, then the property will be confiscated without any compensation. That is number one. The Benamidar and the person who is involved in this transaction will be prosecuted from 1 year to 7 year rigorous imprisonment, and there will be a fine also to the extent of 25% of the value of property. So anything which was considered legal before 30-40 years have been now considered as a criminal act or having the consequences. So one has to understand the nuances of those, why those were being done, and how we can take care that the transactions which have been done in the routine will not fall in the category of that. And for the officers of the department who are also attending this webinar, it will help them in identifying the cases which will have the Benami elements. So to start with, as I already mentioned, that Privy Council decisions are there, and then even the Indian Trust Acts, Section 81 and 82 recognized Benami properties. Then later on, the necessity of knowing that which property is in the Benami name, so that at any stage after 10-20 years, the person cannot come and claim the Benami nature of the property and claim the ownership over that. So in 1976, Section 281 capital A was introduced in Income Tax Act to get the information of Benami properties within 1 year from the date in which the transaction has been effected by the person. If that is not done, then the person could not file any suit to claim that property. So this was basically to get the information on record that such and such properties are Benami. There was no legal or criminal consequences to it. Then various committees were there later on which recommended curbing of Benami practices, which are basically to defraud other laws. So what are the motivations for Benami transactions? Obviously, no transaction can be done without any motivation. So first and foremost motivation is to defraud public revenues, be income tax, it is GST or any other tax laws, or that stamp duties and other revenues. To avoid that, the transactions are done in Benami names. Then other aspect is defraud creditors. As I mentioned earlier, As far as third party is concerned, the Benami property holder is a real owner, and the person who gave the consideration and maybe the real owner is basically camouflaging it in the name of the Benamidar. And therefore, the creditor, while recovering any dues from the person, cannot claim over the Benami property. So this was another motivation to defraud the creditor. Then defraud any law, because there are multiple laws which has some requirements to fulfill before any action can be taken. And if the person does not fulfill the requirement, the same can be done in the Benami name. Then to avoid penal consequences under securities law, under Securities Contract Regulation Act, there are many transactions which are not supposed to be done by certain individuals in different capacities. Insider trading is one of the important law there. And to avoid that also, the Benami transactions can be done under securities market. Then to hide transactions from the limelight. A person is already in the limelight. He doesn't want that the public at large should know that I have entered in so many transactions. Then he may hide it by doing it in Benami name. Then deployment of corruption money. Obviously, corruption money cannot be deployed in one's own name. It has to be only in the Benami names. Then override Land Ceiling Act. Earlier, we all know that there were Land Ceiling Act and there was a restriction to hold the land up to a particular limit. So anybody holding land beyond that limit, they were motivated to transfer in the name of Benamis. There are certain family arrangements also in which the properties are transferred in the name of family members in the Benami capacity. Then to distance oneself from the real transaction. A person does not want to face the consequences and the wrong effect of any transaction. Then one will do it in the Benami name so that if any negative thing comes, the Benamidar will face the consequence. So these are some of the motivations of Benami transactions. Then Benami legislations, as I told earlier, that after 1976, when we started looking at it and various committees were formed, there was a necessity felt that to curb the black money and the various nuances which I have mentioned in the earlier slide, the Benami Transaction Prohibition Act in 1988 was formulated. But then there was no rules formed in that. So for next 28 years, till 2016 Amendment Act, those were not implemented because there was no machinery provisions, there were no rules, no administrative mechanism in that. That entire act was only of 9 sections. Then the Amendment Act came in 2016, which in fact had 72 sections. This is a code in itself. But since the government or the parliament never wanted that for those 28 years, from 88 to 2016, person entering in the Benami transaction should not go unpunished. That is why it was made as an Amendment Act and many provisions were applied retrospectively. However, Supreme Court decision in the case of Ganpati Dealcom in August 2022 declared that this act will be applicable for Benami transaction only with effect from 1st November 2016. So whatever Benami transactions have been done prior to November 1st, 2016 will not be having the effect. And in fact, department has launched or rather initiated proceedings in respect of more than thousands of the cases. And many of those were even confirmed in adjudicating authority level also, but those were all quest. This decision I will be discussing little later. Yeah, what are the consequences of Benami transactions? Anybody entering in a Benami transaction is a punishable offense, can be punished under Section 53 of the Amended Act. The punishment is from 1 year to 7 years rigorous imprisonment. So that is the immediate consequence. There is a prohibition on the right to recover any property held as Benami. As I told earlier that the consideration payer could have claimed rights over the property from the Benamidar, but that is not possible and after this act. then no defense can be made based on any right with respect to Benami property, and Benami property is liable for confiscation. This is a very, very important provision. Whatever property is held to be Benami will be confiscated by the government without paying anything in return. No value will be paid against that. It will be free of free confiscation. Then there is a prohibition on the retransfer of property by Benamidar as per section 6.3. The Benamidar cannot retransfer the property if it is held to be Benami. So these are the consequences of Benami transactions. Next slide is very important because this deals with the Benami transactions, and that is the crux of the entire law. So if I will be devoting a little more time here, and I will expect the participants to understand the nuances under this definition. So there are 4 types of transactions which are considered Benami. First is very, very important in that, and that says any transaction or arrangement where a property is transferred to or held by a person. So first element of that is property is transferred by a person. The consideration of such property has been provided by another person. So this is another aspect, that the consideration for the purchase or holding of the property is paid by another person, and the property is held for the immediate or future benefit, direct or indirect, of the person who has provided the consideration. So there are 3 limbs of this. One is a property is transferred in a person A, the consideration of that is paid by other person, that is person B, and the property is held for the present or future benefit of the person who paid the consideration. Means if B has paid the consideration, then property is held for the consideration of for the benefit of the B. So the property is to be held for the benefit of the person who is paying. The payment is to be made by the other person, and property should be in the name of a person. So that these are the 3 limbs of it. Unless all 3 are there, the transaction will not be treated as Benami. So as I have given the example, A and B, A purchase the property, B provides the consideration, and property is held for the benefit of B. It is a Benami property. But take the other case where A purchased the property by borrowing from B. The property is not kept for the benefit of B. B's interest is only in the recovery of loan. In this case, this 3rd limb is not satisfied. Property is purchased by A, provided consideration is provided by B, but the 3rd limb is for the benefit of the person paying consideration is not present in this. Therefore, it is not going to be Benami property. So all 3 has to be fulfilled together to constitute or to declare any transaction as a Benami. But there are certain exceptions to it. All transaction will not be considered as Benami even when these 3 criteria are fulfilled. First category of exception is HU. In the case of HUF, we all know Hindu undivided family, where there are co-partners and Karta. If the property is held in the name of Karta or a member or a co-partner, then from the known sources of HUF, then it will not be treated as Benami property, Benami transaction. Here, the known source I will like to explain in detail. Known source does not mean the taxable income of the HUF. It could be even the borrowed fund of the HUF. So that is why the word used here is known source. That legislature has not used the word the assessed income or from own source. So from own known source, if the payment is made by the HUF, then the property is in the name of Karta or any co-partner, it will not be treated as Benami transaction. Other exception is a person standing in a fiduciary capacity. There are many fiduciary capacity persons like trustee in the case of trust, guardian for that minor, executor, receivers and liquidators for companies in liquidation, partner in the case of partnership firm, solicitors and advisors for clients, and directors for a company. So these are the categories of persons. Even if the consideration is paid by the other person, property is in their name, and it is held for the benefit of other person paying consideration, it will still not be treated as Benami in these cases. And government has a right to aid any further person in this category. Then third and fourth are related to transaction between related parties. Third one is basically a individual transacting in the name of his spouse or in the name of any child of such individual, paid out of known sources of individual. Again, everywhere the word known sources is used. I'm not explaining every time because it is not the text or assessed source. It is basically a source from which it could be borrowed or it could be own source. So if in the case of individual, if the transfer or property is purchased in the name of spouse or children, then it will not be treated as Benami. But there is a difference between this and with the relatives. Like if it is in the name of brother or sister or lineal ascendants or descendants, then it has to be in the joint ownership. Out of known sources of the individual that is required. So basic distinction between 3 and 4 is, in the case of spouse and children, if the property is in the name of spouse and children alone, it will still be not treated as Benami. But in the case of brother, sister, parents, lineal ascendants or descendants, then it has to be the joint ownership. If it is in the individual name, then this will be considered as Benami. In fact, I have seen in my past, even in 90, in one of the search, a broker purchased shares in his name and sent those shares for transfer in the brother's name. Funds were paid by him. It was basically for his own benefit. So definitely it would have fallen in the category of Benami. So like that, many such transactions are prevalent, but this fine distinction has to be kept in mind that in the case of spouse and children, there is no requirement of joint ownership, but in the case of brother, sister, and other persons, the joint ownership is required. So this is basically the first category of Benami transaction. Now, second category, where the transaction or an arrangement in respect of a property carried out or made in fictitious name. If the property is purchased in the name of a fictitious person who does not exist, or a fake name or a shell company, then probably the transaction can be categorized as Benami. Here, the name holder of the property is a fictitious person, not a real or existing person. So it will be treated as Benami. The third category is a transaction or an arrangement in respect of property where the owner of the property is not aware of such ownership or denies knowledge of such ownership. In this case, the person exists, but he denies that he says that I'm not the owner, or he denies the knowledge of such ownership, that I'm not aware. Like a property is purchased in the name of a driver or a servant. He is not aware. So he denies the knowledge. Then in this situation also, it will be considered as Benami transaction. And the fourth and last category is a transaction or an arrangement in respect of a property where person providing the consideration is not traceable or is fictitious. The so-called beneficial owner or the person who is providing the fund himself is not traceable, or is a shell company, or is a fictitious person, then also it will be treated as Benami. So there are in total 4 types of transactions which can be categorized as Benami. First is where a person holds the property, or a transfer is there in a person A's name, payment is made by B, and property is held for the benefit of B, then it will be Benami. And there are certain exceptions which I said in the case of HUF, in the case of company and all other categories, and then relatives and family members. And then there is another category where property is in the fictitious name, it will be Benami, where the owner of the property denies the knowledge or is not aware of the ownership, then also it will be Benami. And if the person who is providing consideration is not traceable, is not available or fictitious, then also it will be Benami. So these are the four categories, four types of cases where transaction can be held as Benami. What is Benami property? Benami property is basically any property which is subject matter of Benami. It's very simple. What is Benami property? Anything which is a subject matter of Benami transaction, and that also includes the proceed from such property. If that property is sold and some money is received out of that, even that proceed also will fall in that category. Then what is the property? Property is basically, here it is not just immovable asset. We generally consider property means land, building, or some immovable property. But here all kinds of properties, movable, immovable, tangible, intangible, corporeal, incorporeal, and that includes rights, interest, legal documents, instruments, evidencing title to or interest in any property. So all these are also considered as a property. And where the property is capable of conversion into some other form, then the property in the converted form. There are some properties like any rights in the company or any kind of warrants which gives right to acquire shares. So those, if are converted in shares, even that is also a property, and also includes proceeds from that property. So whatever money is realized from that property, that will also come in that category. Now, some examples of Benami properties, just to illustrate what kind of properties are held as Benami properties: FDRs, deposits, savings in cooperative banks and cooperative societies in fictitious names. It has been noticed, in fact, in the past that certain cooperative banks and cooperative societies were having fictitious accounts and deposits. And all those are examples of Benami properties. Assets or properties held in the name of non-PAN holder or person having no or meager income. This can be a potential Benami property. Prima facie, this can be a Benami property, but one has to prove it further, because just not having PAN or not having sufficient income will not be a conclusive evidence of Benami property. We have to take it to the test we have discussed earlier. Then house, flat, land, or other immovable property in the names of drivers, servants, poor relatives, but used by the money provider. These are the clear examples of Benami properties. Stock in trade, goods kept in warehouse, cold storage under fictitious names. There are many cold storage and warehouses where goods of other companies or other businesses are kept. If those are kept in fictitious names, then those are also Benami properties. Property in the name of shell companies, that is without doing any business and having fictitious addresses. So those properties also will be Benami properties. Land purchased in the name of employees from the funds provided by employers. So this is also a category where, because in the case of normally an employee, the fiduciary relationship will not be there in the case of company or employer. It is different in the case of director or a company. So any property purchased by an employee from the funds provided by the employer, it will be in the category of Benami property. Then there are examples of Benami transactions similar to this: share application money or shares held in Benami names, either by promoters or investors. There are many promoters who are keeping, just to keep them away from their promoters group and all, they keep in the Benami names. Even some investors want to get away from the limelight, they keep in Benami name. So those are all Benami transactions. In fact, earlier when there used to be an IPO craze, applications in the IPOs, initial public offerings, were made in multiple names. And obviously, the consideration is provided by one person and applications are made by 10, 20 persons. Other 15, that other remaining persons would be Benami, wherever shares are allotted. Securities transactions in some Benami names, purpose of which can be to avoid taxes or to avoid insider trading regulation by key management personnel or the person having price sensitive information. As I mentioned earlier, certain persons who are having price sensitive information in their possession are barred from trading in the securities market. But then they do that in some other people's name. That is Benami transaction can fall in the category of Benami transaction. The other purpose could be to evade taxes. If it is done in the Benami names, fictitious names, then that will be again in that category. There are unaccounted assets kept in bank lockers of other persons. There are cases, in fact, during searches also we found that bank lockers of the employees and relatives and other persons were used in keeping cash and other unaccounted assets. So that will be falling in the category of Benami asset. Benami transactions, cars and other movable assets purchased in Benami names but used by the real owner. That also will be the Benami assets of Benami transaction. Land aggregators using brokers or other persons in temporary transfer of land. It is seen that many land aggregators who are aggregating land in a particular area, they don't buy land in their own name. They use brokers and the other persons to acquire the land first so that the price does not shoot up. And then later on, they transfer those lands in their name or their company's name. So those transactions are also in the nature of Benami. Then who is basically Benamidar? Benamidar is a person or a fictitious person in whose name Benami property is transferred or held, and includes a person who lends his name. So anybody who is basically in whose name the property is transferred is a Benamidar, and who lend his name is also Benamidar. Who is a beneficial owner? The person who is paying the consideration. Basically, a person, whether his identity known or not, for whose benefit the Benami property is held by the Benamidar, is a beneficial owner. And here, this person pays the consideration also. So what are the criteria to identify that the person is having the Benami property? The first and foremost thing we need to see is intention of the parties concerned during the purchase. What is the intention of purchase? Is it basically to defraud some revenue or something else? Or it is just a family arrangement? Then source of consideration. Who is providing the source of consideration? That is another important aspect. The motive for giving the transaction a Benami color. Why it is being given this color? The position of the parties and the relationship between the parties. Like employer-employee, owner-driver, servant, close relatives, those kind of relationship and relationship between the parties, that also will give clue to this. Custody of title deeds after sale. This is a very, very important aspect. A person who is providing consideration would definitely like to keep control over the asset. And the control of any property is basically title deed, original title deed. If the person is keeping the title deed in his custody, he or she is supposed to be held an honor. In one of the search, we have noticed that more than 400 property documents were kept at one place. This is owned by the person searched. That was a clear indication that those properties were held as Benami by that person. Relevant circumstances depending upon the facts of the case. These are very important. Who is managing the property? Because obviously, whoever is having an interest in the property will manage the property. Who enjoys the fruits? Like if property is given on rent, who is effectively getting the rent from that? If it is a land, agriculture land, who is basically getting the benefit of the crop and all? So all these are the factors which will determine whether the transaction is Benami or not. There are some other relevant issues relating to the Benami transaction. Before going to the next topic, I would like to just briefly mention these also. Property purchased with power of attorney holder, power of attorney under section 53A of Transfer of Property Act, where consideration is paid and possession is granted. Stamp duty is paid and agreement is registered, but seller still holding the ownership title is not treated as Benami property. This is by way of explanation. This has been added after the bill was introduced, because there are many cases where attorney holder does not have the title in his name, but he has already paid the consideration. Possession is also taken. So in that case, exception is provided, whether the stamp only when the stamp duty is paid and agreement is registered, then also it will not be treated as Benami property. Then in the case of religious and charitable trust, a lot of anonymous donations are received. So questions were raised in parliament that what will happen to those donations? Will it be treated as Benami? Then the amendment, or rather the section 58 provides that such anonymous donation will be exempt from the Benami. In the Companies Act 2013, there is a requirement that information relating to beneficial shareholding is to be provided by the company within a month to Registrar of Companies. This information can be in the case of fiduciary relationship shareholdings or intercompany shareholding kept for the benefit of other company, holding company or subsidiary company. But if this relates to the category of Benami, then probably this can give a good clue to the department. And in fact, some cases have been developed from this information. There is a informant reward scheme for Benami transactions also, like informant scheme in the case of income tax searches. So these are some of the relevant issues I thought I'll mention. Then coming to the execution part of this act, there are 4 authorities defined under the act. First authority is initiating officer, who is at the level of Deputy Commissioner of Income Tax in Benami Prohibition Unit under investigation wing. Then there is approving authority, his immediate boss, Additional Commissioner of in charge of Benami Prohibition Unit. And then administrator, when the property is confiscated, somebody has to administer the property. For that, one ITO is posted as administrator in Benami unit. And adjudicating authority, where the provisional attachment order goes to the adjudicating authority, which is only one at the moment in Delhi and not under Benami but under PMLA. So there are 4 authorities at the moment under Benami. Then how the attachment and confiscation goes, the brief description of that is here under section 24. Wherever there is a belief that the person is a Benamidar or there is a Benami property or Benami transaction, he can, officer initiating can issue a notice and provisionally attach the property for 90 days. If he thinks that the person can alienate the property, can sell or dispose of during this period, then attachment is done, and then after that, within 90 days, order has to be passed confirming that attachment, of course with the approval of approving authority, which is Additional Commissioner. And if initiating officer passes order continuing the provisional attachment, he shall within 15 days of the date of attachment draw up a statement of the case and refer it to the adjudicating authority. So he has to refer it to adjudicating authority in Delhi, where the powers are again given under section 24(6) and the subsequent sections. The conditions which are required for initiating issue of notice: there has to be a property, there has to be material in possession of the officer. Based on the material, initiating officer has reason to believe that a person is a Benamidar. Means the all elements which I have discussed while discussing a Benami transaction has to be present. He has recorded reasons in writing and then issued notice to beneficial owners also. Then once he passes order and it goes to the adjudicating authority, then adjudicating authority passes order within a year, and within 30 days he has to give notice to Benamidar, beneficial owner, interested parties and any other person who claims that property. So all these proceedings are there before adjudicating authority. Here, adjudicating authority can either confirm the attachment or revoke the attachment. If he confirms the attachment, then the property can be confiscated. If the other side does not go in further appeal in tribunal, then confiscation order will be passed under section 27, and then property will be of the central government. Once the property is confiscated, then within 7 days, a notice will be that administrator, which is ITO as I mentioned, will issue a notice to the possession holder to surrender or deliver within 7 days of service of notice. And then as per the law, he can dispose of the property as per central government rules. In brief, these are the provisions, or rather avenues available with the taxpayers, Benamidars or beneficial holders. how the cases are developed and built. The prima facie detection or identification of Benami transaction, and then it is to be brought to the notice of initiating officer, because initiating officer gets references from the field formation, from the searches, or from other agencies. On his own, he may not have the input about it. He gets the reference from other people. Then he initiates the attachment of property. Then it goes to the adjudicating authority in the green, and then adjudicating authority confiscate, pass confiscation order. And if matter goes to tribunal or high court, they have to wait, or otherwise it will become final, and the management is of the property by the administrator, that is ITO. This is how in brief the discussion about property confiscation, attachment, and management. Imprisonment, this is a prior to 2016, not relevant now in view of Supreme Court decision. After 16, as I mentioned, the rigorous imprisonment to the Benamidar as well as beneficial owner or any other person who abates or induces any person to enter Benami transaction, it is 1 to 7 years plus fine. So now it is not up to 7 years. Minimum is 1 year. Wherever a person is held to be Benami, the minimum imprisonment is 1 year. Investigation from the Benami angle, the first point of suspicion is person in possession of the property does not have financial capability. So this is the first point actually one need to go into, and then identifying the source from whom the money for purchase is received, then identifying the property clearly, identifying the real intention of the beneficial owner and the persons who helped in carrying out the transaction against whom the proceeding will be initiated. If it is immovable property, identify who is maintaining it, like rent, who is receiving the rent, electricity, water bills, etc. are paid by whom, property tax is paid by whom. So all these details are to be collected before initiating any proceeding. Now, coming to the Supreme Court decision, as I mentioned, which has really set at rest all the controversies relating to the old act, whether it is retrospective or prospective. And briefly, 5-6 conclusions in that decision, I'll just read out. Section 3(2) of the unamended act, that is old act, 1988 act, was declared unconstitutional. And accordingly, 3(2) of the new act is also unconstitutional. In 3(2) of the old act and new act is basically a prosecution of up to 3 years. So that is held unconstitutional because there was no, the criminal act cannot be held, applied retrospectively. Section 5 of the unamended act is declared unconstitutional for being manifestly arbitrary. The section 5 of unamended act was basically acquisition of the property by the government, that was declared unconstitutional. So no proceeding can lie prior to 1/11/2016. 2016 amended act is merely a procedural, but it prescribed, it not merely a procedural, but a prescribed substantive provisions. It was argued before the court that the amendments are merely procedural, but court held that this is not a procedural. It has many substantive provisions and therefore cannot be applied retrospectively. Section 5 of 16 Act is punitive in nature. Section 5 is basically confiscation of property and it can be applied prospectively only. Then all prosecutions and confiscations proceeding for transactions prior to 1/11/16 quest. So whatever orders of confiscation or adjudication, etc., have been passed prior to 1/11/2016, everything is quest and there is no proceeding now in those cases. The question of constitutionality of 16 provisions are left open. So in fact, those provisions will be tested in future, but we can very well safely presume that those provisions will be held applicable in the transactions now being treated as Benami. Now, relevant posures. Just to clarify these provisions more in more detail, I would like to address these questions and answer. Whether Benami Act applies to undervaluation of assets also? No, because undervaluation of asset is in the domain of income tax and not in the Benami Act. If any property or asset is undervalued, that can be treated as investment partly explained under Income Tax Act, and addition of that can be made there. So Benami Act does not apply here. Next is, in case of home loan, consideration is paid by lenders and properties in the name of buyers, will it attract Benami law? In the case of lender, as I mentioned earlier, lender's interest, though consideration is paid, lender's interest is basically in recovering the land, not in getting the benefit from the property. So therefore, it will not attract the Benami law. Next is Mr. X purchased property which is registered in his name for rupees 5 crores. Rupees 2 crores paid from the amount declared, but 3 crore from unaccounted sources. Will property be treated as partly Benami as it is not funded from the known sources? In this case, property is purchased by X in his own name. Funds were also provided by him only. So there is no second person available here. Only difference here is that out of 5 crore consideration, 2 crore is declared in the books and 3 crore is unaccounted. So this is a case of tax evasion, and proceedings under Income Tax Act will lie, not under Benami Act. During income tax search on X, wife of Mr. X admits that she is a partner in the firm, but she did not know her share and other details. Will it be a Benami transaction? I will say that just by not remembering her share and other details, it will not become a Benami transaction. Only where it is held or it is proved that her share of partnership came by the money provided by X and she is holding the share only on behalf of X, then only it can be treated as Benami, otherwise not. Benami transactions also covers transactions where persons paying consideration is not traceable or fictitious. What happens in the case of charities where donors wish to remain anonymous and provide consideration? So in this case, in the charities and institutions, charitable institutions and religious institutions, any anonymous donation received will be covered by section 58, where it is provided that it will not be treated as Benami. Next, whether power of attorney transactions in immovable properties are Benami transactions. Normally, power of attorney transactions can be treated, but if it is part of section 53A of Transfer of Property Act, that is as per the doctrine of part performance, in which 4 things are done. First is possession given, consideration paid, stamp duty paid, and registration done. If these 4 things are done, then even if the property title is still standing in the name of seller, it will not be treated as Benami transaction. The next is it necessary that Benami property has to be located in India? There is no rule under Income Tax Act that a Benami property has to be located in India only. However, when this issue was discussed in Parliament, Honorable Finance Minister made a statement that foreign properties will be covered by Black Money Act, which is relating to the foreign assets. So that will not be applicable to Benami property. And even in the Black Money Act, that beneficial interest in the asset located outside India will be covered under the Black Money. So I believe the Benami property will get covered under the Black Money Act. There is no necessity of bringing them under Benami Act here. Next is, in every transaction of a property by an individual in the name of siblings to be regarded as Benami. The transactions with siblings, brother and sister, if it is in the joint name and from the non-source of income, non-sources, then it will not be treated as Benami. However, if the transaction in the name of sibling with the full consideration and there is no joint ownership, then it will be treated as Benami. Next is, in a 20-story building, 10 floors are in the name of a person who provided consideration, while the remaining 10 floors are in Benami names. Will the entire property be treated as Benami property? In this case, 10 floors are in the name of a person who provided consideration. So obviously, those 10 floors cannot be treated as Benami, but the remaining 10 floors are in Benami names. So those only will be treated as Benami property. Next is, if an individual purchased property in the name, in the name of his mother, father, grandparents, will it be regarded as Benami? If individual purchased in the name of parents or grandparents, from his own sources, it will be treated as Benami, because it will not, unless it is in the joint name, it will be treated as Benami. The complete ownership, or rather the name of, is possible in the case of spouse and children. That is not there in the case of parents or grandparents. Property was purchased in the name of director, but money was paid by the company. Will this transaction be regarded as Benami? If the company has paid the consideration and the transaction of the property is held in the name of director in his fiduciary capacity, then it will not be treated as Benami, because it will fall in the category of exception number 2. Then, is Benami law in conflict with Income Tax Act? Benami law and income tax law are in 2 different domains. Benami law deals with the Benami properties, Benami transaction, whereas Income Tax Act deals with evasion of tax or taxability of the income. So there is absolutely no conflict. They complement each other. Wherever there can be interplay in some cases, but there is absolutely no conflict. In case fictitious owner is a Benamidar, how can notice be served and how this transaction be dealt with under Benami law? There is a possibility, because there is one category of Benami transaction where Benamidar is fictitious. Obviously, the notice cannot be issued to a fictitious person, but in this case, the property is existing and the beneficial owner will be available. The notice will be issued to the beneficial owner and to the property. A holding company holds shares in its subsidiary company in the name of its nominee to ensure that number of members in the subsidiary do not fall below the statutory limit. Is this a Benami transaction? Here also, the fiduciary capacity, fiduciary relationship comes into play. And if the transactions are between holding company and subsidiary companies through their nominees who are acting as a fiduciary, then it will not attract the Benami law and it will not be treated as Benami transaction. During demonetization, money deposited in Jan Dhan account be treated as Benami. In fact, we have noticed that during demonetization time, in many Jan Dhan small that person's account, the monies have been deposited and those were taken to a different account or kept for some time. So obviously the money was given by some other person and for the benefit of those persons. So those are in the category of Benami transactions only. If no order is passed under section 24(4), 24(4), as I mentioned, the initiating officer has to pass the order within 90 days. If he issues a fresh order under 24(1), means again provisional attachment for the same property on the same basis, on the basis of same material. I don't think on the basis of same material and on the same property, he can issue fresh notice under section 24(1) if he has not passed order under section 24(4) confirming the attachment. So that is that liberty is not available to him. There has to be some different, some extra material available to initiate proceedings again. Whether Benamidar is covered in prosecution, even if his name has been entered without his knowledge or concurrence. If the Benamidar is not aware of the transaction, his name is entered without his knowledge or without he concurring to the transaction, obviously prosecution cannot be filed against him or he cannot be prosecuted because he has done no wrong. He is rather victim that his name has been used. So I don't think a prosecution can be launched against such Benamidar whose name has been entered without his knowledge or concurrence. Then what about the spouse being purchaser of the property purchased by husband, not from a known source? Here, the property is purchased by husband in the name of wife, but the source is not known. So obviously, it will be covered in the case of Benami because exception provided under the Benami transaction section 2(9) clearly says that property purchased in the name of spouse or children from the known source of individual. Since it is a case of not from the known source, it will be treated as Benami property. Next question is gold bullion found in the locker of the firm during search and partners claimed ignorance and denied ownership. Will it be Benami? So during search, in the locker of the firm, they denied the ignorance, they denied their ownership, and they claimed ignorance. So in that case, obviously, it will be treated as Benami. Also, if they accept ownership but unable to provide the source of purchase, whether Benami. So other situation will be they accept the ownership that just it belong to them, but they don't have the explainable sources for them for the purchase. In that case, it will become undisclosed income under Income Tax Act, but it will not be treated as Benami. While verifying unsecured loan appearing in the balance sheet of the assessee, creditor denies the transaction or a creditor does not exist. Will it be a Benami transaction? The loan appearing in the balance sheet is basically to be treated under Section 68 of Income Tax Act, where the creditworthiness, existence of the creditor, genuineness, all factors are to be seen. If that is proved to be not correct, then the addition can be made under Section 68. But just on the basis of unsecured loan appearing in the books and the person denying the transaction or creditor doesn't exist, it may not be treated as a Benami transaction. However, if a property is purchased directly from the fund provided by the person who is not existing, then it will be treated as Benami. So here are some of the posers I have given, and now I'm open for questions. So I'll just see if there is any question in the question box. I'll stop sharing. If anybody has any question, you can please mention that in the question answer or chat. I'll be able to answer that. Or else, yeah, one question has come. Case found in the locker of employees and he has knowledge. Will it be covered under Benami? Yes. In this case, the question says that the case found in the locker of an employee. He is in knowledge. But whose case it is? If it belongs to him, then it will not be Benami. But if it belongs to his employer, then it will become Benami. Because the property consideration, rather the property belonged to the employer, kept in the custody of employee. So it will be a Benami transaction in that case. As I mentioned earlier, that in the case of firm, when the gold and other bullion were found in the locker, if they deny, then it will become Benami. If they don't deny, then it will become income tax, that undisclosed income. In this particular case, it will be a Benami because employee does not have the fund and he could not have contributed to the undisclosed case found. Okay, another question Mr. Sunil is asking is, if my grandfather name is not matching as in ancient time, pseudonym was registered, is it Benami land? No, it may not be Benami land because what we are talking is, again, the transaction done from 2016 onward only will be considered. So this is obviously ancient time, the old name was registered and pseudonym was registered. So that will not fall in the category of Benami. So one can be rest assured that such transaction will not. You mentioned the actual name was Ramnik Soni and pseudonym was Babu Bhai. So it doesn't matter. It will not make any difference. The property continues to exist in his name and it is not acquired or transferred now in the Benami name. So I think there is not an issue. The next question is, by Mr. O.P. Agarwal. What are the implications of property purchased in joint name with spouse? Consideration fully provided by husbands from non-source. This is a very common practice. In fact, in the case of spouse, property need not be purchased jointly. If it is purchased in the spouse name alone also, it will not be treated as Benami. Only difference is the source has to be known, to be disclosed. If it is not disclosed, then there will be a problem. So I think there is no issue. The joint ownership is required in the case of siblings or in the case where there is a property in the name of ancestral, that ascendants or descendants. So in the case of wife or children, even joint ownership is not required. It can be directly in the name of spouse. Sir, property is purchased. Mr. Susil Dalmia is asking, sir, property is purchased and got registered in the name of mother. Would be regarded as Benami? Yes, it will be regarded as Benami because mother, in the case of mother, father, or ascendants or descendants, it has to be only in the joint name. The sole name is permissible in the case of spouse and children only, and nobody else. So if it is purchased in the joint name, all right. If it is purchased in the sole name, then it will be treated as Benami, even if it is from the non-source. Mr. Prahlad is asking, if sundry creditors are not identified and the same has been accepted by the assessee as cessation of income, will the same be treated as Benami? No, it will not be treated as Benami because if these are not identified, it is basically a case of at the most, and you are already offering it for income. So it will not be treated as Benami. It is already come in the books, and it may at the most be a case of section 68. Because for proving anything Benami, as I mentioned in the beginning, there are 4 types of transaction. Unless the transaction falls in any of the category, it will not be falling in that. In this case, if there is a fund directly provided in acquisition of a property and the person is not existing and does not have any, is a fictitious, then only it will come in this category. So I believe just because there is an entry in credit entry, creditor is there, it will not lead to the Benami transaction. I think there is no more questions. So I conclude my session here. Oh, okay, some more questions are there. Sorry, I'll take very quickly. Yeah. What happens if the property is first purchased in joint name with parents and then it is gifted and name is deleted? So this is a very innovative way to remove the joint name. If that is done, I think because that incidence of Benami will come at the first instance. If it is later on purchased and it is gifted and it is not held for the benefit of the individual, then definitely the 3 limb of action will not be applicable, because if you have gifted, you are not keeping it, that the gifted person is not keeping it on your behalf or for your benefit. So in that case, there is no issue. The next question Kanika is asking is, case is seized in the hands of a person while traveling and the person says the same is of another person, B. Person B confirms that the case was his and given to the person A. Person A few days ago. B is not able to give source and justify the reasons for the same. Can you please elaborate Benami implication? Yeah, if case is seized in the possession of B and which was given by A and who is also not able to explain the source, then basically it is a case of unaccounted case found. It may not have immediately Benami implication unless other side agrees that yes, I have given and there is no apparent reason for that. Then only it can be a case of Benami. Otherwise, it will be a case of income escaping assessment. So with this, I conclude my presentation. Thank you so much.